the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, episode 23, with Leslie Tucker, the principal of Williams, Edelstein, and Tucker, and I'm your host, Jonathan Sarr. Today, we're going to talk about a case where a property owner tried to take matters into his own hands and not allow a student to keep his assistant's animal, despite what his property manager and the property management company's lawyer recommended. Leslie, can you take us through what happened here?
I can. Thanks, Jonathan. So in this case, the plaintiff is a college student with physical and mental disabilities, resulting in, among other things, seizures and panic attacks. He has a service dog who he says has been trained to react when these things occur. The plaintiff moved into an apartment with two roommates who both, go to the same university as him. And the community does not allow pets. The plaintiff made the management company aware that he has this service animal and his need for the animal to live with him. And they subsequently approved the animal and included the animal into his lease. However, when the owner of the property found out that there was a dog living in the apartment, they didn't like that. And the principal member of the ownership group allegedly demanded that the management company get that animal out of there. The management company got their attorney involved and attempted to educate the property owner on Fair Housing Act requirements, specifically that the dog must be permitted to live there under the Fair Housing Act because it's needed for a disability-related purpose. The property owner decided, since its management company wasn't doing what it asked them to do, the owner decided to go directly to this plaintiff and asked him additional questions related to why he needed this dog, what the dog did, and why it was needed. The plaintiff's attorney responded to those questions, explaining the seizure disorder, explaining how the animal assists him during those episodes. Allegedly, the owner was not satisfied with that explanation and still demanded that the dog be removed within 48 hours, that the plaintiff, the student, pay the owner's attorney's fees for having to go through this hassle and replace all the carpeting in the unit. He said if this was not done, then the student would be evicted along with his roommates. Well, the plaintiff, the student, did not do these things, and so the owner filed for eviction against the plaintiff and his two roommates. The management company, who was really not involved in any of those decisions, they did learn about it though, and upon learning about it, they terminated their contract with the owner and stopped managing that property. Presumably because they were aware that what was going on was not legal. So even though the owner did eventually dismiss that eviction action before the plaintiff and his roommates were actually evicted, and honestly, based on the information I have, I'm not sure why they decided to dismiss the eviction, but they did. But the plaintiff and his roommates, after their lease term was over, they did move out. He filed a complaint with HUD, and HUD found cause to believe that a violation had occurred here. The case did become a lawsuit. The case did settle, which placed numerous requirements on that ownership company if it ever began owning rental properties again in the future, related to advertising, related to how it responded to reasonable accommodations. It put strict monitoring requirements on the ownership entity. And there was a separate private settlement agreement between the student and that ownership company as well, likely, related to money, but that's not public information.
Wow. I can just imagine our community like saying the same thing. Wow, 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 wow. It's amazing to see something like this with all the education that's out there when it comes to assistance animals, and yet to see something like this still happen. So a question for you, interesting separation between the owner and the management company. So the question that I have, isn't the management company always named as a defendant in these cases? And why wasn't it named in this case?
Yeah, it was interesting and unusual that the management company was not named, because it's almost an automatic given that if something goes on related to fair housing at the property, the management company is always going to be named along with the owner, typically. Generally, the management company is always involved in some way, shape, or form in whatever action is being alleged. This case was different, however, because the ownership entity and the specific representative of the ownership company really kind of took it upon itself to interject and acted entirely outside of the management company's advice. The management company did get their attorney involved. They did try to educate the owner on fair housing responsibilities. And that advice allegedly was completely disregarded. The owner of a property generally has the ultimate authority as to what occurs on the property and what is permitted on the property. So the management company, could have, and sometimes does, they can act based on the owner's instruction. And in this case, the owner's instruction was to remove that dog. However, in this case, the management company, they were educated, they consulted counsel, and they were aware that what they were being asked to do was something that was likely going to place them at a very high risk of legal liability. So instead of acquiescing to that demand and just doing whatever they were told to do, they removed themselves from the equation completely by terminating that contract, that management contract, and getting away from the property. I think that, in light of what these allegations are saying, the management company's actions were smart. They, were acting sort of in their own best interest and protecting themselves, and they saved themselves the hassle of being involved in this lawsuit.
Yeah, I think our community would wholeheartedly agree with you. Yeah, it was good decisions on the management company's part. So another follow-up question then. Could the owner's actions have been proper when it opted to ask additional questions regarding the plaintiff's need for the animal? Is that allowed?
Well, generally, once an animal has been approved as an assistance animal, regardless of who approves that, but once it's been approved, it's generally not a good idea to go back and re-verify or question the approval after the fact. This can occur maybe in another situation where, one manager approves an animal and then there's another manager that comes on after them that didn't really think things were done properly, didn't agree with the procedures that were taking place before them. So that's another scenario where this might happen, but it's still, even if you think an animal wasn't properly verified the first time around, generally not a best practice to go back and rethink, re-verify. The approval generally should stand. I guess that begs the question, did the management company do the right thing the first time around by approving that animal just by the plaintiff telling them, yes, this is a service animal? And the answer is yes. I mean, when it comes to service animals, management certainly can rely on a resident's word that an animal has been trained to do something specific, that it is needed for a disability related purpose. However, if the disability and the need isn't obvious, as was the case here, the management company could have and would have had the right to request third-party verification of the disability and the need. They just chose not to in this instance, and that's okay.
Got it. Okay. Thank you for the explanation. There's a lot of details in this particular case, and I think, as always, lots of lessons learned for our community to pay attention to.
Yes.
So thank you so much for bringing this case to our attention, to our community's attention, and for the explanation of what went on. Another amazing case, episode 23, the Fair Housing Insiders Case Files. Thank you to our community. We look forward to next time. Take care, everyone.